subjected to harassment, intimidation, hazard, threat, or physical assault by any of their representatives or supporters. Now we know what happened. It's not disputed in this case that Ms. Brown is a journalist and she was subjected to harassment, intimidation, hazard, and threat by supporters of the EFF and Mr. Malema. We know that happened. It's common cause. It's just good fortune that she wasn't assaulted. The learned offence is not common cause. Well, it's alleged and there's no proof, there's no evidence to show that it didn't happen. She says what happened. I've read your ladyship the tweets. My learned friend is going to say those tweets didn't happen, well, that will be very interesting. It's plainly by supporters. It is harassment, intimidation, hazard, or threat by supporters of the EFF, by people who assert that they're supporters of the EFF. Mr. Malema and the EFF were obliged to take all reasonable steps to make sure this didn't happen. He was asked to do that. Mr. Malema's response was, I won't do it. And that's really the case, Malema. I have other things I want to say, but that's really the case.
I think we also need to address the obviously on the urgency.
Yes, I will. I will. Yes, I will.
I don't want you to disturb your flow on it.
No, thank you, Malema. Mr. Malema doesn't seem to understand this. Firstly, there are two things he doesn't seem to understand. He doesn't seem to understand that he's not allowed to make false allegations that a journalist is a spy, or an intelligence agent, or as an agent of the state, or a member of state security. He's not allowed to do that. He doesn't seem to understand that. He also doesn't seem to understand that if people who describe themselves as his supporters, the ones I read to you and others, threaten violence against a journalist, he has a legal duty to take all reasonable steps to stop this. That's what the code says. Mr. Malema's response is, I won't do it. We say that at the very least he has to address them. Obviously on Twitter, that's the way to reach them, and say, this conduct is intolerable and it must stop. He doesn't have to send the police out, but he has to take all reasonable steps. And the very first thing he has to do is to say to people, stop this is intolerable and unacceptable. Mr. Manchansha asked him to do it and he said, I won't do it. He considers him free to do it if he feels like it. So we say that when the threats were made, instead of doing what he was obliged to do, Mr. Malema did the following. First, he threw fuel on the fire by repeating and amplifying the false allegations. Firstly, it was just mole. Now it was mole, intelligence, security agent, all of those things. He amplified the false allegations. And then secondly, he refused to do anything to rein in the people who describe themselves as their supporters. And we say that he has breached the code of conduct in a most serious manner. He's published false and inciting material to 2.3 million people, and when some of them have responded by making disgusting and blood-curdling threats, he has refused to condemn this and say that it must stop. He thinks there's nothing wrong with that. We ask the court to say that is a breach of the code of conduct. It has a breach which has had serious consequences. It has intimidated journalists. They say so. And we ask for appropriate relief. Then I need to deal briefly with the claim that Mr. Malema makes that he didn't intend to publish Ms. Brown's phone number. A good deal of the heads of argument is addressed to saying that he didn't intend to publish the phone number. The first thing we say is that doesn't help him, because that's what he did. He published the phone number. And there was then a duty on him to rectify the matter, to stop the abuse that followed. Instead of that, he threw fuel on the fire and refused. But in any event, we say that his denial that he intended this can't stand up to scrutiny. We say that for two reasons. Firstly, we say that he himself says that he deliberately posted the whole of Ms. Brown's WhatsApp, which had so annoyed him. He didn't publish the whole of it by accident. He published the whole of it deliberately. This is what he says at page 400 comes out when people have to make affidavits. Page 400, paragraph 122. (122.2), my lady. It says, I've specifically rejected the applicant's contention that I published a phone number of intent. On the application of the rules for evidence in motion proceedings, I'm advised that my version in this regard ought to be preferred. Moreover, I point out that the applicant has not dealt with any of my justifications for not tampering with the screenshot I posted on my Twitter account. Namely, I did so in order to avoid accusations of spreading fake news. So his reason for not editing the tweet was that he didn't want to be accused of spreading fake news, and that was in his mind, he says. He thought about it. Shall I edit this? And I said, no, I shan't edit it. I'll publish it as it is because I don't want to be accused of spreading fake news. Now that is, with respect, a bizarre explanation. That's his explanation, not my explanation, under oath. He says that's his justification. Secondly, we say, my lady, that when he saw the consequences of what he had done, he didn't remove the phone number. The consequences became apparent immediately. He must have known, they're doing this, they're able to do this because I gave them her phone number. Because it was his giving the phone number which facilitated and encouraged it. But he didn't remove it. It was only when Twitter said to him, you must remove this or otherwise we will remove it, that he then removed it. And he seeks amazingly in his affidavit to say that shows how I was in good faith because I didn't wait for them to remove it, I removed it myself. That's the most extraordinary proposition. The fact is he didn't remove it until he was instructed to do so by Twitter. And the threat of their removing it itself. So we say that his denial of an intention is contradicted by his own words and conduct. On his own version, he deliberately published the whole of Miss Brown's message, which included her phone number. He doesn't say, I didn't notice that it included her phone number. He could hardly say that. He doesn't say anything. He says, I deliberately published the whole thing because I didn't want to be accused of fake news. And then secondly, when the outpouring of bile and hatred followed, he did nothing to remove it. Nothing to remove the phone number, which was obviously facilitating and encouraging this until he was instructed by Twitter to do so or to have it removed by them. And so we say that the repetition and aggravation of we say this, the repetition and aggravation of the false statements from mole to state security, intelligence, operative and all of those things. Firstly, that aggravation after the trouble had started, and then the refusal to condemn the threats throw into sharp light the claim that the publication of Ms. Brown's phone number was unintentional. In any event, even if somehow it was unintentional, the refusal to withdraw his false statements and his refusal to condemn the threats of his followers are the most serious breach of the Code of Conduct. And so we say there's simply no answer to the merits of Ms. Brown's complaints. Then what our learned friends do, what the respondents do, is attempt to throw up a string of technical defences to avoid the merits being dealt with, because they had no answer on the merits. And I mentioned 9 of them here. Firstly, the one that our learned friend referred to, that the High Court does not have jurisdiction. Now that is, with great respect, an extraordinary submission, because we know what the rules say, and we know what the Act says. It's dealt with in our heads of argument from paragraph 15, and I wouldn't have even thought it's necessary to rehearse this, but I'm afraid I must, because it seems to be the whole point. Paragraph 16 of our heads, we say the starting point for the analysis is that this matter concerns an alleged breach of the Electoral Code. In terms of the Electoral Commission Act, Section 20 sub 4, the Electoral Court shall make rules in terms of which electoral disputes and complaints about infringements of the Electoral Code of Conduct may be brought before courts of law. And then in section 24B over the page, that the rules will determine which courts of law shall have jurisdiction to hear particular disputes and complaints against infringements. And so it's for the electoral court to make rules, the Act says so, regarding alleged breaches of the code, and in particular to determine which courts shall have jurisdiction. The electoral court has made the rules. We've quoted them. They're in the ladyship's bundle, but we quoted them. Rule 2 says, the magistrates' court and the high court in whose area of jurisdiction 1B, any complaint about an infringement of the code has arisen, shall have, subject to sub-rules 2 and 3, jurisdiction to hear such dispute or complaint. So your ladyship has jurisdiction, the rules say so. The rules aren't challenged, nor could they be. Does your ladyship have it in the bundle? So it could hardly be clearer. There's a limitation on the jurisdiction, and that there's a limit on the sanctions which your ladyship may impose. That's dealt with in section in Rule 2.2. The High Court can impose all the sanctions except the sanctions in section 2H and I. We don't seek those, so your ladyship has jurisdiction. And we say with respect, it couldn't be clear that the rules provide that the electoral court and the High Court have jurisdiction to hear a complaint. Paragraph 22 over the page. This issue of going to the, well, let me say 21.1, top of page 9. Where an applicant seeks a sanction in terms of section 96.2H and I, those are the ones excluded from your ladyship's jurisdiction. That is an order disqualifying a candidate or cancelling the registration of a party. Then the applicant is required to approach the electoral court. That's the only court that has jurisdiction. But where it seeks any other relief, as Ms. Brown does, it's entitled or even possibly obliged to approach the High Court. And that issue arose before this court in the ANC versus DA. The ANC brought an application alleging the dissemination by the DA of an SMS text message alleging that President Zuma, quote, stole your money to build his 246 million rand home and that it infringed the electoral code. The first question the court addressed was jurisdiction. Considered section 24, and it held that this court has jurisdiction in the interest of a free and fair election to impose any appropriate penalty or sanction on a person or registered party that's contravened Chapter 7.1. The court then also considered whether it was functioning as an electoral court or functioning as a high court with ordinary inherent powers, or as both. And your ladyship will find the findings of the court at the top of page 10 of our heads of argument, in paragraph 25. The court concluded in terms of the rules, the electoral court may only be approached as a court of instance when a violation of the Electoral Act or the Electoral Code might justify a sanction in terms of section 96.2H and I of the Electoral Act. That is, disqualification of the candidate or cancellation of a registration of a party. Now that is a difficult question, and we don't ask your ladyship to make that finding. It's a difficult question. It is a finding of this court. But most importantly, by 25.2, in all other matters, those justifying a lesser sanction of those in section 96.2H and I, the relevant High Court or Magistrates Court has jurisdiction. When the matter comes before a High Court, it has the power to impose all the sanctions except H and I, and in such cases, an appeal lies to the Electoral Court with the leave of the High Court or failing that the leave of the electoral chairperson of the Electoral Court, which is the final arbiter of disputes. In other words, paragraph 26, the court held that a party is not only that a party is not obliged to approach the Electoral Court, but is not entitled to do so. But in any event, we're here in this court, your ladyship has jurisdiction. This court now sits, when it hears this matter, in the hierarchy of the electoral jurisprudence. An appeal from your ladyship's decision lies to the Electoral Court. Your ladyship is sitting here in that line of authority. And it's not as though we're going outside the line provided for in the Electoral Act. We're inside the line. We're in the court prescribed by the Electoral Act.
Can you please address the issue raised by Mr. Bulwana, that when there's a specialist court, that court is to be court?
Yes, but these are the rules of that specialist court. These are the rules made by the specialist court. The specialist court said, when you've got a complaint about the code, you can go to the High Court, and there will be an appeal to us. So there's no conflict of jurisdiction here. The Electoral Court says, go to the High Court. and if there's an appeal, come to us. So it's not a situation where there are parallel jurisdictions and you've got to choose between two jurisdictions. There's one jurisdiction, there's the jurisdiction created by the Electoral Act, and that jurisdiction is Magistrates Court, High Court, Electoral Court, and we're in that line of jurisdiction. And that's a determination made by the specialist court, the Electoral Court. So this court concluded, paragraph 27, we quote the court's conclusion. I don't need to go there. Well, perhaps I should read it. This court hears matters such as the one at hand as the High Court, not as an electoral court. In other words, the jurisdiction of the High Court is extended pursuant to Section 96(2) of the Electoral Act, written with Section 24(b) of the Electoral Commission Act and the rules to allow to hear such cases. The High Court doesn't become an electoral court for these purposes, and the learned judge could have added a sentence, and an appeal then lies to the Electoral Court, which is the specialist court. Paragraph 28, we make, of our heads of argument, we make the point that the ANC versus DA case went on appeal to the Electoral Court, and then it went to the Constitutional Court, and it was never suggested on appeal that this court had improperly exercised jurisdiction. It was in the rule, in the list of authority. Is this a convenient time for your ladyship to adjourn?
Absolutely, can just take it to adjourn. I just want to thank you. I just want to find out, Mr. Pearson, how much are you?
As the court pleases, my lady, regrettably we're still await a compliant service affidavit. We hope to have it by the end of the tea adjournment.
Just take a short tea.
That's what sole jurisdiction is.
And that's what the Constitution
Section 20 sub 4, the middle of the page, I've already referred your ladyship to, that the electoral court shall determine which courts of law shall have jurisdiction to hear particular disputes and complaints about infringements. And then 20 sub 5, the hearings and appeals referred to in subsection 4 shall enjoy precedence in the courts of law determined in accordance with that subsection. So the legislature has determined that a case such as this shall enjoy precedence. In other words, there's only one reason for that, and that's because it's urgent. It's by its nature urgent. Otherwise, why would they enjoy precedence over other cases? And so I'm not aware of any other provision in our law which does that. I may be mistaken, but it's very unusual for the legislature to intervene and say, we tell you these are urgent cases, hear them first. That's with respect to what the Parliament has said. The second reason we know it's urgent is because of the rules which the electoral court itself made. The electoral court, we know, is the body which supervises all of this. And if your ladyship will go to the rules, those rules start at page 145 of the bundle. If your ladyship will go to page 147, your ladyship will see the rule dealing with applications such as this. And I can take your ladyship to rule 4 sub 5. The application must be lodged in the appropriate court having jurisdiction. 4.6. The respondent must, within 3 days after receipt of the application, lodge an answering affidavit. And rule 4.7. The applicant must, within 2 days after receipt of the answering affidavit, lodge a replying affidavit if any. Now that's a determination by the electoral court that these matters are urgent, because otherwise it would make no sense. Just as Parliament saying give these matters priority has determined that they are urgent, so the electoral court, acting consistently, making its rules, said it's so urgent, it's 2 days and 3 days for the filing of affidavits. The third reason we say it's urgent, we say that's with respect enough, but we say the third reason it's urgent is because the election is to be held on Wednesday. And this is a case about the functioning of our constitutional democracy. It's by its nature urgent. And we say that it is desirable and in the public interest and in the interests of justice that the matter be ventilated before the election, because the public have the right to know about this before they vote. And we say that it is desirable and in the public interest and in the interests of justice that, if possible, the matter be decided before the election. Now, we appreciate that places your ladyship under extreme stress, and we've dealt with that in our heads of argument at paragraph 153.
Also, one of the aspects to consider is the congested state of the urgent role.
Yes, I'm sure. I don't even want to imagine it, yes. But if your ladyship will see paragraph 153, we say, ideally we respectfully submit that the court should endeavour to give its judgment before the 8 May 2019 election. It may do so in one of 2 ways. Firstly, it may issue an extempore judgment owing to the urgency of the matter and the implications it has for the freeness and fairness of the elections, or it may grant an immediate order with its reasons to follow. We say even if the court is unable to give a decision before the national election, its decision will have implications. Now, our learned friends leap on that and say, see, you don't even care whether you get a judgment before the election. No, we do. We ask your ladyship to make an order at least before the elections. If your ladyship is in a position where she can't, of course, no one could criticize that, but we would have to just live with it.
But the concern that I just had is that clearly the matter is of great importance to all the parties concerned.
Yep.
And it requires a full and proper and detailed consideration that we bring now.
That is so, my lady, but with great respect, it's not actually a difficult case compared with the other matters with which your ladyship deals on a regular basis. The facts are quite simple, actually. Once you weed out the chaff. The facts are quite simple and the law is quite straightforward. It can't really be disputed that there's been conduct which has breached the code, and nor can it be disputed that it calls for a remedy. The only question is, what's the appropriate remedy we submit? So, we do appreciate your ladyship's difficulties. One doesn't want to be cavalier about it, but that is our position. Fourthly, we make the point that the applicant, none of the delay can be laid at the applicant's door. She, immediately after these events, she asked the Electoral Commission to institute civil proceedings. And there was then that was a reasonable step given its role and its function. She then pressed the IEC repeatedly to make an early decision on whether it would institute proceedings. The Electoral Commission ultimately decided not to institute proceedings itself, and on the very next court day, Ms. Brown launched this application. She had the advantage or disadvantage. She had the advantage. Her legal team, had the disadvantage that the Easter weekend intervened. But it was launched on the very next day after the next court day after the IEC's decision, not to bring the case itself. And then she set the matter down as early as possible. And we say that under those circumstances, the court will say it's in the interests of justice and it's in the public interest that this matter be heard as a matter of urgency. And for all of the squealing from the other side, there has been no suggestion of any prejudice to them. There's a prejudice to your ladyship. We put your ladyship under pressure, and we regret that. It was unavoidable. But there's no suggestion from the other side that they've been put under pressure, haven't been able to answer. They took the liberty of taking 2 extra days to file their answering affidavit without ever explaining why. They filed on the 4th day, with a weekend in between instead of on the 2nd day. Well, I beg your pardon, on the 5th day, not on the 3rd, instead of the 3rd day. We're making no point of it. We're not looking for score points. But they had the time and they did the job. And there's no allegation of prejudice in the paper. So those are our submissions on urgency. Can I then round off with the other procedural matters raised by learned friends? There's a procedural matter raised about how the matter's been set down and whether it was set down, but the deputy judge president sent it to the electoral judge, and we should have been there. That's all laid to rest by the letter your ladyship showed us this morning, in which the head of the electoral court said this matter has been issued in the High Court and it must be heard in the High Court. That's the end of that matter. Then there's an extraordinary assertion that Ms. Brown can't come to court because she must take the decision of the Electoral Commission on review. But the Electoral Commission didn't make a decision. It didn't have the jurisdiction to make a decision. All it had the power to do was to decide whether to go to court. And it decided not to go to court, as it was entitled to do. We regret that, but it was entitled to make that decision. So there's no review. There's no review of the... This is not a case in which the matter was adjudicated by the Electoral Commission. All they said was, we will or we won't go to court, we decline to go to court. And they said in terms, of course, Ms. Brown can go to court. And your ladyship will find that at page 330 of the record. I hope, yes. This is the Electoral Commission's response to the request that it institute proceedings itself.
I just need to get there.
330. This is what the Electoral Commission says in paragraph 12. Given that there remain disputes of fact and there are issues outside the jurisdiction of the Commission, the Chief Electoral Officer will not be instituting or joining proceedings against the EFF and Mr. Malema, which Ms. Brown may institute. In addition, they won't join in laying criminal charges. So they recognize that it's for Ms. Brown to decide whether she's going to institute the proceedings herself, because her rights are affected, and she's done so. And so the suggestion that there's an administrative action which requires a review, a decision which requires a review, is without foundation. The short point is the Commission made no ruling, made no decision on the merits of the case. It expressed its opinion about some of the issues, but it made no decision and made no ruling because it had no power to make a ruling, and it knew it had no power to make a ruling. And so that point is without substance. Then, my lady, the next point raised is that the matter is moot because of the apology. I've dealt with that, and I'm not going to go back to that. Then I'm sorry, lady. I'm running away with myself. Then there's the complaint raised that this case can't be brought because there are pending criminal cases. Well, that's utterly without foundation. It's dealt with in our heads in paragraph 102. There's no reason at all in law why civil proceedings can't be brought while criminal proceedings which may or may not ever eventuate are pending. And the criminal case is actually about a different case. The criminal case is about a charge of harassment and intimidation. It's not about the electoral code. So it's a different case. Mr. Malema is not prejudiced in answering here, and he hasn't made any allegation that he hasn't said anywhere here, I can't answer because I'll be prejudiced in my criminal prosecution. In fact, the material facts are common cause as to what he did. So the complaint of a pending criminal case dealt with in our heads, paragraph 102, we say has no substance. Then, finally, there is a complaint which says, I'm not sure whether our learned friends persist in it. They say that what Ms. Brown should have done is send them the phone numbers of the people who abused her, and they would have dealt with it. Well, that is the emptiest of offers. Firstly, for two reasons. Firstly, Mr. Malema himself refused to condemn the intimidation. He said, I won't do it. So what would be the point of telling him the names of the people who committed the intimidation? He said, I won't do it. And secondly, this tweet was sent to 2.38 million people. We don't know, nobody knows, which of those people are liable to violence or not liable to violence. It is what one does know is that people who are going to engage in violence may not give advance notice of it and give you their phone numbers. And so the suggestion that all you have to do is send a tweet to those people who identify themselves and say, don't do it, and that somehow will cure the problem, is utterly empty. It leaves out 2.38 million people minus about 20 or 50 or 100 or whatever it is. I don't know what the numbers are.
But is Mr. Malema's explanation of that, does it not say, if you tell us who they are, you give us means by which to identify them, we can discipline and we can take disciplinary action?
Yes, that may be, and maybe that should be done. But it doesn't deal with this complaint, which is that he breached the code, he incited 2.38 million people, and some of them responded by Twitter and some didn't. So maybe they should all be given to him. And of course, he probably has them now from the papers, I don't know. But it could be given to him. But it's not a cure, that's the point. It's not a cure. And if he would discipline them, that would be very welcome, I'm sure. So we submit, my lady, that there's no answer on the merits. And there's been a breach, there's been a serious breach, there's been a refusal to remedy it, and the belated apology goes nowhere. I do need just to say this, that it's also not cured by saying at a press conference, we are against violence against women. And in the very same breath, pouring fuel on the fire. And one doesn't want to use abusive words and insulting words, so I shall refrain from doing so. But it is, at the very least, the statement of that we're against violence against women is empty when at the same time, in the same breath, A, you pour fuel on the fire, and B, you refuse to condemn the threats. of violence. I won't do it. So that's entirely empty.
Can I ask you one issue, just to address me on it? That is, what is the nature of the sanctions in Section 96(2)?
Yes. Yes.
Are they of a penal nature, and if so, what is the test that is to be applied in determining conduct there?
Well, there are some penal and some which don't really easily fit within penal. Can I take your ladyship through the ones which we seek? And I'll say something about that. The first order we seek is a declaration. A declaration that there was a breach of the code. Now, that's not penal in its nature. Our learned friends say, but why do you need a declaration? You can't get a declaration just for the asking. Well, we say the following in response to that. Firstly, we say the declaration is the foundation for the relief which is to follow, the apology or the fine or whatever it may be. You don't get there unless you make a finding that there's been a breach. And so we ask for the declaration that there's been a breach. That's the foundation. And that's why this case is different from all the cases our learned friends rely upon about how you can't get a declaration in the air. That's right, but you can get a declaration when there is consequential relief. And this is a case for where we seek a declaration with consequential relief. Cases about declarations in the air don't really assist us in respect. So the first reason is that we need a declaration is that it is the foundation for what is sought. The second reason is that it's quite clear from the papers that Mr. Malema and the EFF still don't understand what they've done wrong. They think all they did wrong was unintentionally, so they say, publish a telephone number. That's the only admission of any guilt at all, which they say was not a breach of the code. And so we say the court should make a declaration so that next time Mr. Lemma and all other people will know that this sort of conduct, inciting this sort of threat and then refusing to condemn it, is unlawful, it's intolerable, it's not taking all reasonable steps. So that's the second reason, is because Mr. Lemma doesn't understand what his obligations are, and the EFF. The third reason is that the public need to know. The public need to know that Mr. Malema and the EFF broke the rules designed to ensure a free and fair election. The public are entitled to know that, if they did it. That's the purpose of a declaration. And a declaration is specifically provided for. So that's the declaration. Then,
perhaps before we move on, go to 96. Declaration stands outside of 96.
yes, it does. It stands outside of 96. Yes, that's right. I'm wrong to say it's provided for, it's not. It can may in the interest of a fair election impose any appropriate penalty or sanction on the person or party concerned, including. So these all seem to be sanctions or penalties of one kind or another. They're not criminal, but they're sanctions.
What my concern is there is if you look at the full-bench decision or the full judgment given by Justice Cameron in the constitutional case of the ANC and the Democratic Alliance, it's the ultimate conclusion of the judgment you rely on.
Yes.
His Lordship, Mr. Justice Cameron, warns of the importance and the fact that it is of a penal sanction nature and that the requirements of it must be strict.
Yes, because that case was about free speech in the end. That was the tension.
Yes.
Fair election versus free speech, and the necessity of free speech for a free election. And so you have to get the balance right in this respect. But we say, let me put it this way, if Mr. Lemma had said people should assault Ms. Brown, if he'd said that in terms, your ladyship would have no difficulty. Your ladyship would say that's way over the bounds of free speech to incite behavior, to encourage that. This is the effect of what he did, because he uttered inciting language, and then when consequences followed, he didn't say stop. He said what I said was fine, and he repeated it and he aggravated it. And that's why it falls outside the bounds of free speech of this kind contemplated in the ANC and DA case. It wasn't just, if all he had said was Ms. Brown is a mole, and if it had no consequences, then we would be in ANC versus DA territory, perhaps, about whether it was true and whether it was protected by free speech. But when it has these consequences, he has an obligation. The code says he must take all reasonable steps to stop intimidation and violence. He refused to do so. So the declaration is we refer to. The second thing we ask for is a formal warning under section 95(2)(a). And the purpose of a warning is really because section 95 contains escalating sanctions. And one can see that if there's a repetition, you may go from 1 to 2 to 3 or to 4. And so a warning is a warning which says if you do that again, you may find yourself in even more serious trouble. You may get to the stage where your participation in elections could be questioned. So the warning is a warning that this can't continue. What happens with this escalating consequences, and it's relevant, particularly relevant in this case, where there is a history of these hit and run incidents. Then the third thing we ask for is an apology, and we have referred your ladyship to the case law on the power of a court to order apologies. And I'm not going to take your ladyship there except to say the case to which we refer is no, I lost it. What is it? Case of apologies. Oh, it's the Mountain Oaks Winery case. And there, her ladyship, Justice Bokwana, went through all the cases dealing with apologies, showing how the Constitutional Court, judges, not in the majority yet, the SCA and High Courts repeatedly have said you can order an apology. It's a proper order for the court to make. Not just for defamation, but more generally. For an injuria, in the Day case it was not for defamation, it was for an injuria. In the Mountain Oaks case it was for a trade misrepresentation. So the power to order apologies being held applicable to defamation, to injuria, and to trade misrepresentation. And we say the same must apply under this Act. Finally, we say as to remedy, we ask for a fine. There, your ladyship is at large. It's very difficult to put a number to it. We don't say that this is a case for the maximum fine, which is 200,000 rand. We suggested a fine of 100,000 rand. Actually, the most important thing is a fine. That's what sends the message. And we don't obsess about the number, but we do say that a fine would be an appropriate remedy because it sends the message and it is a deterrent, as long as it's not purely token. So, lady, those are my submissions. Costs. As far as costs are concerned, as we've said in our heads of argument, we ask for costs of 2 counsel if we succeed. And we say that in relation to the Rule 30A proceedings, which were an outright abuse, we ask for costs of 2 counsel on the attorney and client scale. As far as what happens if we are unsuccessful is concerned, we refer your ladyship respectfully to the decision of the Constitutional Court in the Barkhuizen case. It's Barkhuizen versus Napier, 2007, Part 5, SA, 323, paragraph 90. It's the majority judgment of Justice Norval. What happened, your ladyship will remember in Barkhuizen what was happened. Barkhuizen was a private individual who was suing Napier, who is representative of the insurance company. So the usual rules about costs against the government didn't apply. And this is what the court said, and Mr. Barkhuizen failed in his application. Or in his application for leave to, in his appeal, I beg your pardon. He failed in his appeal. And this is what the court said in paragraph 90. This is not a case where an order for costs should be made. The applicant has raised important constitutional issues relating to the proper approach to constitutional challenges to contractual terms. The determination of these issues is beneficial, not only to the parties in this case, but to all those who are involved in contractual relationships. In these circumstances, justice and fairness require that the applicant should not be burdened with an order for costs. To order costs in circumstances of this case may have a chilling effect on litigants who might wish to raise constitutional issues. I therefore consider that the parties should bear their own costs in both courts and in all courts. This is a case which, to adapt the words of Justice Norval, which raises important constitutional issues relating to the proper conduct of an election and what is permissible and what is not permissible. We say that the determination of those issues is beneficial, not in Barkhuizen, like in Barkhuizen's case, beneficial to people who enter into contracts, beneficial to all of us, the entire population who participate in democratic elections. Because the fair conduct of elections is fundamental to all of us. It's not just a case about contracts. And we say that to order costs in the circumstances of this case would be likely to have a chilling effect. The next time a journalist is threatened, she ought to have to say to herself, not only do I have to put up with this, not only do I have to face the consequences of the threat and live in fear for my life, but I can't go to court to protect myself because I may fail and I may be hit with a costs order. And so the chilling effect is dramatic, and rather more dramatic than the case of Mr. Barkhuizen and his insurance contract. It goes to her fundamental rights. So for all of those, but we submit that with respect that the application ought to succeed. If your ladyship is against us, we ask that no order be made as to costs. Those are our submissions. Thank you for your patience.
Mr. Nkowana, I have not had the chance to fully read your written arguments. Please assist me to emphasize certain aspects.
Lady, it is tempted to jump headlong and address our learned friends inaccurate factual submissions, many inaccurate submissions, or rather observations. One hesitates to call them submissions with respect up front. But we need to take a step back and look at the context of this case. My lady will be aware of the judgment of the Supreme Court of Appeal in Scalabrini. I don't want to belabor the point, but context in law is everything. So let's start with the context. In our highs of argument of principal submissions, we deal with this from paragraph 4. It begins at page 8 of 40. Perhaps the good point to begin is the WhatsApp message about which has brought us here. And that is the message of Ms. Karima Brown, which you'll find at KB3, it's paragraph 45 of the papers. In my pagination, I noticed that I may be a page or so out. When I compare my pagination with my Lawyer Junior immediately to the right, there seems to be a discrepancy in our pagination. So, my lady, mine is at paragraph 45. It's KB3. Alex Jack KB3.
Mine's also at 45.
Yes. So far, so good. But we'll get to a point where the pages don't talk to each other. Now, I shall read the text. She says, keep an eye out for this. Who are these elders? These elders, are they all male, and how are they chosen? Keep watching brief. Then Mr. Malema retweets the tweet as it was. And he tweets the following. Karima Brown is sending molds to our breakfast with the elders tomorrow. She incidentally sends the message. I think that was meant to say accidentally, but let me not edit what is already in the papers. She incidentally sends the message to EFF South Africa Media WhatsApp group and deleted it immediately. Now, the immediate question that arises is, why would one have that interpretation to a seemingly, and I emphasize the word, seemingly innocuous tweet? The answer lies in what the first and second respondent perceive of Ms. Brown. Not in the air, but from what she has said publicly about the EFF and against the EFF. What we have done, my lady, is to collate these statements. There are about 4 or 5 of them, dating back from 2018 in November. If I may hand them up. Now, one of them appears at page 171, but I'll get to that. The EFF has been critical of Ms. Brown, as Ms. Brown has been critical of the EFF. In most trenchant terms has she been critical of the EFF. If we could start with the first quote in the public domain. On the 25th of November, in her program, she says, this has to do with the SANEF application in the Equality Court when SANEF said they are going to talk to the EFF and so on. She says, the threat of journalists, we have seen SANEF saying that they will be meeting with the EFF. I quite frankly think a meeting with the EFF is pointless. We're going to see spectacle and drama as usual. They've used every opportunity to actually harass journalists, and then there's a bit left out there. And then she says, we've seen an incredible amount of race baiting. So she accuses the EFF of race baiting. Then in the Citizen of the 6th of March, we foreshadowed in the paper. I'll tell you in a moment. Just find out when we foreshadowed these. Tell me in a moment. Then in the Citizen, she says, why a party which threatens women journalists being allowed to contest elections? She asked, she's quoted as asking, adding that the IEC should investigate if the EFF is, quote unquote, fit to be a political party, and if are they functioning in the constitutional parameters of a party. She's then quoted as saying, we need to ask the IEC how such a party can be on the ballot box. It threatens journalists It encourages its supporters to make rape threats and sexual assault threats. It wants to dictate what I can do as a journalist, where I can work, who I can work with. It harasses women. It physically attacks us. How is such a party allowed to be part of a constitutional democracy? And they are never arrested, fined, or face any consequences for their actions. How do they promote democracy? How do they live up to the Bill of Rights? That's my question. Today it's me, tomorrow it's person X. This is how fascism starts. This is the kind of person calling herself a journalist according to the EFF, speaks of the EFF.
You know, I'm sorry to interrupt. Can you just be shown where in the papers these exposed?
Yes, I've asked my junior to find the places. I can tell you immediately that the one of the 8th of March to which I come now is at page 171 of the papers, where she says, Kate, this is penultimate one, my lady, at the bottom of the page, towards the bottom of the page. Kate, can you give me the process of how I lay a charge against Julius Malema and end EFF? I want to take the matter to the electoral court. I have a case now with the police who is investigating the matter as well. Kind regards, Karima. Now, at page 1, well, in my pagination, I know that much. It's 171. So I've asked my juniors to just locate those.
What are you looking for?
Yes.
I have it at 171 at Karima Brown.
Yes. But there is an actual text. I think it's an annexure to those papers. JSN 8, I think. 207. Thank you. Yes, at 207. It's an annexure to a response by Mr. Malema in the complaint that she laid with the IEC. It's at 207. No, that's not the one. The actual point is. Sorry. Yeah, that's not the one. I'll have it found in due course. So, this is the journalist with which we are dealing, or at least the EFF is dealing. A journalist who is intent on having a registered political party effectively deregistered. She doesn't use those words, but effectively she says the EFF has no business participating in South Africa's constitutional democracy. That is the context in which the EFF looks upon the tweet. It's eminently reasonable with respect to submit. But when you deal with a person who says these kinds of things about the party, you then receive a text message like this. It is reasonable that you can have you can give it the kind of interpretation that Mr. Malema has given it, and then he responds in the manner that he has. No, it's not this one.
That's what's repeated in the article.
This one. So therein lies the context. And once that context has been established, we submit Mr. Malema in the EFF can never be said to have responded in an irrational way that encourages people to attack a journalist, that encourages people to harass a journalist, that encourages people, I don't know if they go on to say, to rape journalists. Now, my lawyer friend referred to a judgment that she says is about free speech, which is the ANC versus DA matter. In a way, this is also a free speech matter. I hear some chuckles to my left. I'll explain that. When one is confronted with this kind of utterance by a journalist, is one to sit idly by and not point out the concerns that the person perceives in the tweet or the WhatsApp message that the journalist has put out? We submit not. And so they have a right too to express their opinion on what the journalist is saying in the manner in which they interpret it. Now, I'll just digress a bit and seek some recourse to a famous investigative journalist in the name and shape of John Pilger, who said there are many journalists who are troubled by their own place in the so-called media society. This is a person who's been a journalist since the age of 17. He says, but are also worried about their own jobs. Now, it is possible, and I put it no higher than that, Madam, that certain journalists would follow a particular course in the manner in which they report or opine journalistically on issues in order, as John Pilger says, to keep their jobs. Because with respect to vitriol that one has seen is otherwise inexplicable, as the EFF raises the concern. Now, in paragraph 14 of our heads, we set out what the press code says. And I asked my lady from paragraph 14 onwards to compare what the press code expects of journalists with what I have just read. Whether that is the kind of thing or statements that the code countenances of a journalist. We submitted paragraph 18 that the applicant has not conducted herself in a manner that is objective, fair, and professional, as journalists are expected to behave towards the first and second responders. We say her personal disdain for the first and second responders are palpable. So that is the context. I've asked, we'll give the references later.
Even if that is the context, sorry to Mr. Moran, even if that is the context against which this is to be viewed, how do I then consider the conduct that the applicant complains of, and it's not it's leave the retreating as one. It's take subsequent conduct to failure to act. How does that prevention retire?
Yes, I'm coming to that.
Makes sense what I'm saying.
Yes, if my lady doesn't mind, I am coming to that very point later on in my argument.
I will not disturb you.
Yes, and the starting point, perhaps let me, just by reference to the papers, the lady has regard to section page 178, paragraph 27 of the papers, and, well, if the pagination still holds, and page 391, paragraph 94 and following, where Mr. Malema sets out what he has done in order to do precisely that of which my learned friend accuses him of not having done. But I'll come in a moment if my lady can put a finger on that, because I want to do this in a sequential fashion, otherwise we get lost. So it's 178 paragraph 27 and 391 paragraph 94 and following. So, having started with placing this matter and the facts in their proper context to submit, we then go and deal with the urgency matter. After that, we deal with the jurisdiction point and the abuse of this court's processes. And then we get to deal with the declaratory orders. We submit that the declaratory orders are not, a case has not been made out for them. And then we end up by dealing with the penalties and the sanctions that they seek. Our little friend's case for urgency essentially is this election. We all know what the standard for the hearing of urgent cases is. It's trite. One has to satisfy the court that one will not be able to be afforded substantial relief in due course. There is no suggestion that if the lady were minded to order an apology, that this would not be substantial in due course. There is no suggestion that if my lady were minded to award the fine that they seek, that this would not be substantial in due course. But let's start with a very bold submission that is made right at the outset. When our learned friend says, well, cases that fall under the Electoral Act, or that are brought in terms of the Electoral Act, the Code, are inherently urgent. With respect, that is not what the cases say. I mean, for example, we deal with this at, what is this? This is footnote number 24 in our heads of argument. In paragraph 64, the court always retains the discretion to dismiss a matter for level of urgency. And the footnote refers to the ANC candidate list matter in the Free State, which was dismissed for lack of urgency. It was an electoral court matter, or a matter based on the Electoral Act. And equally importantly, Rule 10B of the electoral rules says or requires the applicant to set out clearly and succinctly the circumstances that render the matter urgent and the reasons why the claims made could not be afforded, or the applicant could not be afforded substantial redress in a hearing in due course. So it's not a given that simply because you bring an application in terms of the rules of the electoral court that the matter is urgent. You still have to make out a case. But the difficulty is, Maredi, the conflation by the applicants in their papers of, on the one hand, the rules of the electoral code, and on the other, the uniform rules of court. Once we get to the terrain of the rules of court, one also seamlessly gets into the terrain of the practice directive, the practice manual of October 2018. The applicant has conflated the two, which has created this difficulty. Because in terms of two judgments of this court, one by Noche AJ and the other by Webinar J, sets out instances where, or requirements for bringing and setting down a matter in the urgent court. At paragraph 6 and 7. And the applicants have, with respect, made no attempt to meet those requirements in those two cases. For one thing, the papers run in excess of 500 pages, and they knew at the time they filed their replying affidavit that this would be the case, because by that time, the papers were running in excess of 350 pages. Secondly, this matter raises grave constitutional issues. We summarize them. We summarize them elsewhere, not under the at paragraph 75 of our case of argument. One of the issues this court has to determine is a very difficult and submit jurisdiction point. The other is whether an applicant that relentlessly attacks a political party, as evidenced by her public utterances, can reasonably be said to be consonant with the press code. That is not a simple matter to decide. Thirdly, whether a journalist who attacks a political party outside, as we submit, the parameters of journalistic pursuit and the press code, is entitled to the protections normally afforded the media by the Constitution. And also whether the explanation given by the respondents for the view that they took of the applicant's WhatsApp message is reasonable. We say these are by no means questions that are easy to determine. The judgment of Webinar says an urgent court is not equipped to deal with complex matters of law. The applicant would have known this in bringing this application on an urgent basis. Now, Here is another related point in this regard. Rather, it seems separate, but it's quite related. The applicant first went to the Independent Electoral Commission to complain about the very same codes, electoral codes, alleging the breach of electoral codes. Now, the simple exercise of my lady we can do is to look at the notice of motion in paragraph 1.3 at page 3 of the papers. The notice of motion says it seeks a declaratory order that the first and second respondents have contravened clauses 2, 3, 6 and 8 of the Electoral Code. And everything else flows from that. That is really the crux of this application, is to seek that declaratory order, because once the declaratory order has been made, then flows the apologies and the fines. But if a declaratory order is not made, then it follows that the other remedies do not follow. Now, comparing that with the complaint that Ms. Brown brought to the Independent Electoral Commission, you'll find that my pagination says 315. I'm not sure if that would accord with yours. It is a decision of the IEC. I'm told it started 314. It's dated 14 April 2019. But the relevant excerpt that I wish to refer my lady to, comparing the two, is at 315. Paragraph 5, where at the bottom the IEC sets out in relation to what codes Ms. Brown approached the IEC. They say in the last two lines on that page, Ms. Brown contends that the EFF and Mr. Malema contravened sections 1, 3, 4, 6, 8, and 9 of the code. That is exactly what they are complaining. She is complaining about here, except for clause 2. Clause 2 is the only new complaint that is brought before this court. But the rest are matters that were raised before the Independent Electoral Commission. Our learned friend then jumps and says, but we didn't seek the same relief. But what's important, my lady, is the code that was invoked. The codes that were invoked are the same here as they were in the Independent Electoral Commission. And the Independent Electoral Commission made a decision on the basis of those codes, or on the basis of the attack on those codes, or in relation to those codes. It said in some instances that it doesn't have jurisdiction to deal with them, but it made specific findings in relation to 8 in the final decision. And that would be, my lady goes to page 328. That is the final decision, I understand. Eh? Oh, perhaps to make things easy, we've prepared a table which will show you where or what code was invoked before the IEC and what code has been invoked in this court, what the decision, if any, of the IEC was, and where you will find that in the papers. So, for example, you see that clause 1 is implicated before the IEC, but the IEC didn't make a decision on it, and it is not implicated in this court. Clause 2 then is implicated in this court. We haven't included it here, but Clause 3 was implicated before the IEC. The IEC says it doesn't have jurisdiction, and then it's also raised before this court. Clause 4 was implicated in the IEC. It is not implicated here. And then Clause 6 is both implicated and decided on by the Independent Electoral Commission. It says there was no evidence by Ms. Brown in support of the allegation that Mr. Malema undermined the role of women in political activities. That's a definitive finding. And then in Clause 8 was also implicated before the IEC, as is also implicated here. And the IEC says no breach of Clause 8A could be found in respect of the publication of Ms. Brown's number. It says no evidence in support of the allegation that EFF and Mr. Malema were in breach of Clause 8C in respect of the offensive messages from the so-called supporters of members of the EFF. And it then says it's unable to make a determination on whether the statements made by the EFF or Mr. Malema casting aspersions on Ms. Brown's role as a journalist. And then Clause 9 is raised before the IEC. And I think here it's not raised in the notice of motion, but is raised in the body of the founding affidavit. So the point we make in that regard, lady, is here you have a Chapter 9 institution, an important cog in the constitutional framework in the country, which makes a decision on the basis of complaints raised with it in relation to the electoral code. The applicant is not happy with that decision. It then embarks on a collateral attack by coming to a different forum, which is this court. Now, imagine for a moment if a public protector were to make a determination, and then a party is not happy with the determination of the public protector, then runs to the High Court, implicating the same issues, albeit seeking a different relief, but implicating the same underlying issues. There would be outrage by the court, and rightly so. Because then what is the point of having a Chapter 9 institution to make decisions if they are simply going to be ignored and the litigant runs to court for a lateral finding? Now, our learned friend says, well, the IEC said it didn't have jurisdiction, so it didn't really decide the issue. But we all know that failure to make a decision is a ground for review. So she could still have brought the application to review the decision of the IEC, not attack, not bring a fresh application collaterally to the High Court. So we say the application is, one, not urgent at all. In fact, the suggestion made that it seeks to to vindicate the applicant's rights as a journalist is with respect a red herring, because those same rights, I'm not saying her wanting to vindicate her rights is a red herring, I'm saying the suggestion that she wishes to have those rights vindicated now, or the basis that's given for that argument, is quite frankly a red herring. And some of those issues, well, yes. Sorry, Monica, just a moment. So what we say, my lady, is that this application, this is what I was looking for. The applicant says that she is now looking beyond this election. She says she wants a determination that a politician cannot abuse journalists in future. But why is that necessary to be determined now? Why can't that be determined in due course if it relates to future conduct and not conduct immediately before the 8th of May, which is in 2 days' time? No case is made out for that. In any event, and assuming that the applicant is correct, the matter will be heard 2 days, or is now being heard 2 days before the election. And the so-called chilling effect has already abated, if it existed at all, because the election was proclaimed a long time ago, and certainly before the conduct complained of here. There is a certain period just before the election where no electioneering or campaigning is allowed. That is where we are now. So the applicant is free to report freely on activities of the EFF and in relation to the election. No case is made out to say, well, this is a specific example of why journalists would not be able to perform their functions if this order is not granted before the 8th of May. And in any event, to the extent that the applicant seeks the relief to apply in the run-up to these elections so that journalists can cover EFF events, the applicant's relief is meaningless because the EFF has already had its final verdict. So she's still free to cover, and any other journalist is still free to cover those events. Now, in paragraph 71 of our heads, my lady, that's the issue that we're talking about in relation to two fora. I'm now dovetailing into the jurisdiction points. we call it the Twin Peaks approach that she's pursuing, demonstrates that the matter is not urgent at all, because the applicant cannot both consider herself to be compelled to engage in the IEC resolution resolution processes, and then assert a right to approach a court in ignorance of and despite the IEC's findings. She must challenge the findings of the IEC on review. And significantly, the fact that the applicant wants to have the matter heard, and this is important, not resolved, because she wants it heard urgently, but she's happy to have the decision of the court given after the election, does not render the matter urgent. The test is whether, if the matter were to follow its normal course as laid down by the rules, an applicant will be afforded substantive relief in due course. The applicant makes no case in that regard. Now, my lady, complicating matters here is a series of correspondences, because it appears that once the applicant had discovered that they have come to the High Court by using the rules of the Electoral Court, they then sought succor in the Deputy Judge President by sending letters to try and remedy the defect. My lady will have seen those correspondences starting, I think, from the 29th of April or 25th, and then running to the 3rd.
Just probably to you.
Attached to our heads of government.
So attached to your 30 application.
They are attached to the heads of argument too.
And also the court's responsibility.
So I'm not going to read the letters, just to highlight a few issues. That the application is brought within strict time parameters, using sort of attenuated time frames of the Electoral Court, but brought in the High Court. The respondents raise the issue and say, but hang on a second, this matter belongs in the Electoral Court. They respond and they say, no, you are simply trying to kick for touch, is what the friend says, to get out of having to deal with the merits that we raise. We write back and we say, no, that's not the case. In the meantime, the Deputy Judge President, as I understand the facts, then sends a letter to the parties, effectively saying, referring the matter to the Electoral Court. And then some 3 or 4 or 5 days later, on the 3rd of May, we receive a letter from an acting Deputy Judge President who says the matter is in the High Court. And there's no suggestion in that letter of the 3rd of May that the decision of the DJP on the 29th of May, on the 29th of April, has been rescinded. Now we've got 2 conflicting decisions from the office of the Deputy Judge President.
The letter of the 3rd of May.
Yes.
Do I find that? I don't have a letter dated 3 May.
It's the second annexure, I'm told, to our heads of argument. I'm told he came after the answering affidavit. So there you will see, my lady, the letter from Acting Deputy Judge President Victor, who says the correspondence in relation to the matter has been referred to the office of the senior judge in the urgent court of this court for this week, and that all further inquiries should be addressed to that court. Now, Justice Mujapelo's letter seems to say quite the opposite.
That's clearly a later letter which says here to the judges dealing with the motion.
Yes.
Here is the correspondence that flowed between the parties, including the letter that I showed you this morning.
Yes, I'm coming to
The
that.
one from the chairperson of the electorate to get to the attention of the person dealing with it in the urgent. Is that not the purpose of this letter?
Well, let's take it step by step. 29 April, the Deputy Judge President says he's received letters of the 24th and 25th of April from the applicant's attorneys and from the respondent's attorneys. And he says he's referred those to Honorable Justice Mba as the President of the Electoral Court. And we are requested to direct all correspondence to that office for assistance. So we are now in the Electoral Court. We directed to the Electoral Court. Now this, we're just checking the facts. This comes after our answering affidavit has been filed. So we have raised the issue of jurisdiction, that the matter belongs in the Electoral Court, in our answering affidavit. Subsequent to that, the Judge President says this letter and say, talk to the Electoral Court, because the applicant's attorneys had sent letters to the Judge President of this court saying the matter should be enrolled in this court. Then there is a letter of the 2nd of May. I'm not sure if...
That's the one the judge has.
Oh, that's the one my lady just gave it to us. We are seeing this for the first time today. What we have is a letter subsequent to the letter that my ladies gave us today. The letter that followed the Deputy Judge President Mujapelo's letter is dated the 3rd of May from the office of the Deputy Judge President, but this time by a different person, which says the matter of, she says your letters of 24 April 2019, 25 April 2019, and 29 April respectively have been referred to the office of the senior judge in the urgent court for the week of the 6th of May 2019 to 10 May 2019. That is in contrast to what Justice Mujapelo says. Justice Mujapelo says it's been referred to the President of the Electoral Court. The same office sends a letter saying it's been referred to the senior judge in the High Court.
That comes after. That comes after.
Yes, it comes after the first letter. The first letter is 29 April. The second letter is, as far as we know, because remember we don't have the letter of the second. The second letter is the 3rd of May, which reverses the decision of the Deputy Judge President and says, no, go to the High Court.
I can tell you that the bundle of documents that I received, and I've given them to you so that you can have a look at them, the cover sheet to that is dated the 3rd of May 2019. I received it during the afternoon. April 2019 between the attorneys, a letter dated 29 April from this office addressed to the President of the Electoral Court and to the respective parties. Fifth, a letter dated 2 May from the Honourable Mr. Justice Mba, where direction is sought regarding the hearing of the urgent application. The matter is referred to as Senior Judge presiding over the urgent court. The letter does not refer to the letter from the chairperson of the Electoral Court, Judge Mba, dated the 3rd of May, which was attached to this document.
Yes, no, I accept that. I don't know, we haven't seen that letter. I certainly haven't seen the letter that my lady has just read.
It was in the pack that I handed to you this morning, so that you could make copy.
Oh, no way, we didn't read that. We thought we had to look at the one-page letter that's dated the 2nd of May 2019. But the simple point we're making is this. A decision of the Deputy Judge President, once made, is fotis officio. It's done. You then have another decision from the same office saying something the complete opposite. We say with respect that presents us with some difficulty, because the same office cannot make rightly or validly two contradicting decisions in relation to an important jurisdiction point which we say is determinative, such as this.
Mr. Ngubane, is it not consequent upon the decision of the Electoral Court chairperson to say this matter is not pending in the Electoral Court, which is subject to its own legal prescripts, and it cannot sit as a court of the Gauteng local division where this case was issued and is pending? I suggest the matter be dealt with the court where it was issued. Subsequent to that letter, it is referred.
But that doesn't take...
Her Ladyship Deputy Judge President Victor to the senior judge in this case.
Do I understand my lady saying this is subsequent to the letter of DJP Victor? Because the dates don't suggest that.
The date
this letter seems to have come on the 2nd of May,
it's preceded it.
Yes,
the
it's
letter
preceded.
of Judge Victor comes
on the 3rd, yes. Now, my lady says this disposes of the matter, as I understand my lady. With respect, we hold the view that this letter doesn't take that matter any further. It doesn't dispose of the jurisdiction issue. It simply complicates it.
But it doesn't determine the jurisdiction issue.
No, it doesn't.
Does that not clarify that there's no conflicting judgments from the Deputy Judge President?
With respect,
consecutive rulings pursuant to what was said in the Electoral Court.
With respect, not, because we don't know what led to this decision being made after the first letter is sent. The DJP sends a letter says the matter must be, well, it doesn't say the matter must be referred to the Electoral Court, but for all intents and purposes, when he says the correspondence has been directed to the Electoral Court, arising subsequent to the respondents raising a jurisdiction point, making that very point that this matter belongs in the Electoral Court. And then we receive a letter of the 3rd from the same office saying no, it belongs in the High Court, effectively. That's not what it says, but effectively referring correspondence to a senior judge here. And then in between, we now learn of the existence of a 3rd letter, which came between the two letters. That letter doesn't take the matter any further because it doesn't explain what informed the contents of this letter. When two judge presidents, effectively, when the office of the judge president has made a decision that the matter should go to the Electoral Court and then the same office make a decision that it must go back. This letter simply adds to the confusion. But the point we make, my lady, is simply this, that the jurisdiction point is bigger than this letter. It's more far-reaching than this letter. We say you cannot have the same office reversing itself, reversing its own decision, because that was a decision, that the matter should be dealt with by the Electoral Court. So we submit this is, with respect, an insurmountable difficulty, and a difficulty which may well, and this is not a threat, and my learned friend characterizes this as a threat, because it can't be a threat, because we don't know what the reasons for my lady's decision will be in the event of my lady finding that my lady has jurisdiction to hear the matter. So once we've heard the decision, one of the points that are likely to be raised is the conflicting decisions from the Judge President's office. I thought it fair
I
to
just want to
raise
understand
that.
clearly.
Yes.
The jurisdictional point, is it just based on the correspondence, or is
No.
it also based on the primary argument?
It's
that
based,
there is a specialist court and that's the place you need to go?
it's based primarily on that argument, but these letters add fuel to it, we submit.
Understood.
So the matter is not urgent for the reasons we've stated. This court has no jurisdiction. I don't know if my lady wants to hear me. I see it's after lunch. Or
What is the time now? It's 10, but let's go till 11:30, I'll be 1:30, and then I'll
1:30.
take a
Yes.
truncated adjournment until 2.
yes, thank you, my lady. Now, we're quite alive to the distinction between the cases dealing with labor matters, because my learned friend at least is right on one thing, is that the Labor Relations Act deals with specialist, exclusive jurisdiction, whereas the Electoral Court doesn't have exclusive jurisdiction. But the principles laid down in those cases are equally applicable here. Perhaps one could add the cases which I would have to go back, I don't know how long, whether my lady will reserve judgment or not. But there are cases also in the competition law space. I think it's Section 62, read with Section 57, if I'm not mistaken, that talks about the jurisdiction, specialist jurisdiction of the Competition Tribunal and the Competition Appeal Court. The first case we start with is a judgment of the Constitutional Court in Hoffman versus the SAA. It's at paragraph 30 of our head.
Do you perhaps have a bundle of authorities for me?
That's the first thing I wanted to say when I stood up. It's been a harum scarum running around, my lady. I arrived back in, I'm sorry, the short answer is no, as I understand it. The heads were only completed at 3 a.m. this morning. After we can prepare them subsequently and give them to my lady after court.
See how we go.
Yes. So Noble in that case says the question of testing in order to determine suitability for employment is a matter that is now governed by 7.2. That with 54 of the EEA. And in his view, there is much to be said for the view that where a matter is required by statute to be dealt with by a specialist tribunal, it is that tribunal that must deal with such a matter in the first instance. He's not talking about a specialist court or specialist tribunal. He's not talking about exclusive jurisdiction. He's talking about specialist nature of the forum. Once a specialist forum is set up in order to deal with specific matters or certain types of matters, even where there are other fora that have jurisdiction to deal with that matter, with such matters, preference should be given to the specialist court. That is why they are there. Chirwa and Gaba are with respect to the same effect. Gaba, for example, says, and this is at paragraph 33, the court warns there at paragraph 56 of that judgment. It warns that if litigants are at liberty to relegate the finely tuned dispute resolution structures created by the LRA, a dual system of law could fester in cases of dismissal of employees. It says, once a litigant, and I'll show how the applicant has done this, once a litigant has chosen a particular cause of action and system of remedies, for example, the structures provided for in the LRA, she or he should not be allowed to abandon that cause as soon as the negative decision or event is encountered, such as in this case. When the applicant runs to the IEC, then doesn't like the decision of the IEC, and then decides to take a parallel route and comes to the High Court without taking that decision on review. One may especially not want litigants to relegate the LRA dispensation because they do not trust its structures to do justice as much as the High Court could be trusted. Now, in this case, clearly the applicant doesn't trust the structures to do justice in the Equality Court or in the IEC, because the IEC told them, I don't have jurisdiction to deal with it. Now, I don't know by whom Ms. Brown was represented in the IEC, if represented at all, but certainly if it was our learned friend, he would have known whether the IEC has jurisdiction or not before bringing the application, before launching a complaint in that forum. So now the IEC comes with a decision that says, one, we don't have jurisdiction to deal with some of the matters relating to the cause that you've invoked, but in relation to the others, you don't have evidence to show any link between all these insalubrious tweets or messages that are sent or allegedly sent to Ms. Brown. Remember, Ms. Brown is the only one who sees these messages. They're not on Twitter. They are sent to her phone. So people who don't have access to her phone don't see these tweets. So we can't say it's common cause that those things were sent. And secondly, we don't know, one can't say for certain that the people who sent those messages, let me phrase it this way, there is no rational and or reasonable and or valid evidence to create a link between the tweeting by Mr. Malema of the message sent by Ms. Brown on the one hand, and those scurrilous messages that were sent to Ms. Brown. It's sheer conjecture to say, well, there's a message that is tweeted and then there's an avalanche of hateful speech, basically, that follows the tweet. But the IEC finds there's no evidence to show this link, and the respondents simply rely on the happenstance of these messages coming after. But there is no comparison of what messages had been sent about Ms. Brown on Twitter before Mr. Malema tweeted the message she had posted on WhatsApp. Now, let me say this is very important. In order for a link to be established between the publication of the message by Mr. Malema at KB3 showing Ms. Brown's cell phone number inadvertently and showing what it is that she said to the WhatsApp group, in order to establish a link between that conduct of Mr. Malema posting this message on the one hand and the abusive messages and harassing messages that she received from people who call themselves supporters of EFF, there has to be a comparison with what kind of vitriol did Ms. Brown meet before that tweet. So one can't jump to the conclusion and say, well, because you tweeted this and thereafter there was a lot of messages that are abusive coming to your phone, therefore those people did it because of your message, if you haven't done a comparison with what went on before that. So, but where we were was that one is not free to forum shop, as it were. Where you've chosen a particular vehicle, or you've chosen a particular horse to ride, you can't then midstream decide that this horse is not going in the direction that I wanted to go, therefore I want to jump to another horse which may hopefully go to the direction that I want to go. If litigants were allowed to do that, then you would have that of which Justice Cameron has cautioned in some judgment, which I don't remember. Now, our learned friend says they've come to this court because the rules themselves of the electoral court permit them to do so. But the rules and the act also permit them to go to the magistrate's court. There is no explanation why they couldn't go to the magistrate court. We are alive to the difference in the sanctions, in the sanctions that the magistrate court may make, and the sanctions that the electoral court may make, sitting as the electoral court, and the sanctions that the high court may make. But, for example, the magistrate's court can make damages of 100,000 rand.
Can they give a declarative?
I suspect so, my lady, but I'll have to come back with an authority on that. I suspect there is no reason why a magistrate court cannot give a declaratory order, because the requirements for a declaratory order cannot reasonably be said to be things of which only the High Court is competent. They quite simply, and we set out the requirements when we deal with that matter, to which I will jump in very shortly. We deal with that at page 33 of our case, but I'll come to that in a moment. In fact, as my lady is asking me this question, one is reminded of a judgment of the Labour Appeal Court in a matter where the lower court had decided that the CCMA doesn't have the jurisdiction to decide retrenchment cases where there's only one employee being retrenched. And the reason given in the lower court, the Labour Court, was that that is a very complex matter, more complex than the retrenchment of more than 50 members. And of course, the Labour Appeal Court set that aside. So, what I'm driving at is, although I shall look at the authorities, it seems to me to stand to reason that simple requirements for a declaratory order, such as they are here, such as we explained them, and I'll come to that, cannot be a basis for ousting the jurisdiction of, or not for ousting, but cannot be a basis for saying the magistrate court isn't capacitated enough to give effect to them. So there is still the magistrate court route that they could have gone. But we're not saying they should have gone there. We say they should have taken the decision of the IEC on review. That's the way they should have gone, and not seek lateral relief in a high court.
This would be an opportune time as to the others to take the adjournment.
Oh, they're
Also
already.
afford me the opportunity of just finishing the last particular bit of argument.
All right.
What?
I was doing.
Go. It's good.